Hello and welcome to ThePrint. This is Khadija Khan and today I'm going to tell you about a rather unusual incident which took place before the Delhi High Court this week, where it was informed about the use of generative artificial intelligence chatbot ChatGPT in a petition. In doing so, a bench of Justice Girish Katpalia allowed a plea by a home buyers association to be dismissed as withdrawn, which means the court closed the case because the party who brought it has voluntarily decided to stop pursuing it. During the course of the arguments, however, it struck the senior advocates Sanjoy Ghosh and N. Hariharan, representing the respondents, that the petitioners in this case, who represented Greenopolis Welfare Association, which claimed to be a home buyers association, had erroneously referred to fake courts and fake cases. The lawyers pointed out to the bench that several judgments in the respondents' plea were cited from ChatGPT and asked the court for permission to initiate action against the erring lawyer. The respondents' lawyers also submitted before the court an entire table of cases cited by the petitioners, which the court recorded in its order. On one side, the respondent home buyers put a column of what the petitioners had argued or pleaded, and on the other side, a column detailing the correct or actual position of law was presented. Now, the High Court dismissed the plea as withdrawn after orally observing that the use of AI in such a manner was impermissible and a cause of serious concern. Speaking to ThePrint, senior advocate Sanjoy Ghosh said, "We are shocked that someone had used ChatGPT in this manner. It wasn't just a typographical error, but they had manufactured cases and used ChatGPT's inaccurate information without any verification or cross-checking as should have been done." For instance, one of the judgments cited by the Gurugram-based Greenopolis Welfare Association was the landmark Supreme Court ruling in the 1972 Raj Narayan versus Indira Gandhi case. Although the actual judgment had only 27 paragraphs, the petitioners had cited a 73rd paragraph which did not exist and was entirely fabricated. Another instance was that the petitioner cited paragraph 21 of the 2010 ruling in Dalip Singh versus State of UP, which according to them read, "In the last 40 years, a new creed of litigants has cropped up. Those who belong to this creed do not have any respect for the truth. They shamelessly resort to falsehood and unethical means for achieving their goals." However, the respondents pointed out that the actual para 21 of the 2010 ruling read quite differently. A perusal of the application dated 8 July 1976 submitted by Shri Praveen Singh and so on and so forth. Essentially, what had happened due to the use of ChatGPT was that the para cited as para 21 was actually paragraph 2 of that case. However, this is not the first time that a court has flagged the use of AI by lawyers in arguing cases. While some courts and judges have come down heavily on the use of AI in judicial work, others like the Manipur High Court and the Punjab and Haryana High Court have leveraged its use for research purposes while acknowledging the same in their orders. The Manipur High Court had turned to ChatGPT for research in a service law matter last year in May. In a case concerning the reinstatement of village defense force personnel, but Chief Justice of India, B.R. Gawai, in March this year, flagged the inherent risks posed by the use of AI in such cases. Relying on AI for legal research comes with significant risks, as there have been instances where platforms like ChatGPT have generated fake case citations and fabricated legal facts, the CGI had said while speaking at the Kenyan Supreme Court in Nairobi. In July this year, the Kerala High Court came out with guidelines for the district judiciary concerning the use of generative AI for judicial work. Submitting information such as facts of the case, personal identifiers, privileged communication, or uploading any other documents relating to the litigations to any such AI tools may result in serious violations of confidentiality. Hence, the use of all cloud-based services should be avoided except for the approved AI tools, the official guidelines read. In 2023, Justice Pratibha Singh of the Delhi High Court, while acting on Christian Louboutin's case, had refused to rely on ChatGPT's response presented by the luxury shoe brand. The above responses from ChatGPT, as also the one relied upon by the plaintiffs, shows that the said tool cannot be the basis of adjudication of legal or factual issues in a court of law. She said, the response of large language model-based chatbots like ChatGPT comes with possibilities of incorrect responses, fictional case laws, and imaginative data, etc., generated by AI chatbots, the court had noted. Looking beyond domestic shores, in December 2023, judges in England and Wales were allowed to use generative AI systems like ChatGPT for basic tasks such as summarizing large bodies of text, making presentations, or composing emails, a guidance issued by the UK judiciary had specified. However, this advisory cautioned judges to not use chatbots for conducting legal research or carrying out legal analysis, going so far as to warn them of signs that show legal arguments can be prepared using AI chatbots. Some of the signs pointed out by the UK judiciary for the use of AI were references to cases that sound unfamiliar or have foreign citations, while another is making submissions or arguments which do not conform with the judge's general understanding of the law in that area. And that brings us to an end of today's segment. For more legal updates, stay tuned to The Print.